Thank you so very much for joining us. This is still Enterprise Morning, reaching you from Enterprise Television. Let's head straight to our conversation for today. Nnamdi Kanu's decision to call 23 witnesses, including top figures like Abubakar Malami, Nyesom Wike, David Umahi, Babajide Sanwo-Olu, and Theophilus Danjuma, and equally Tukur Buratai, raises legal issues on competency and compellability under Nigerian law. Section 175 of the Evidence Act, which provides that all persons are competent to testify unless the court finds them incapable of understanding questions or giving rational answers due to factors such as age, illness, or mental incapacity. Even persons of unsound mind may testify if they can comprehend proceedings and respond rationally. In Kanu's case, however, naming high-profile officials is not unlawful, as the law presumes competence. However, compellability, forcing a person to testify, is not absolute and may be limited by privileges or practical considerations. The court must balance the accused's rights to call witnesses with the need to protect state interest and prevent trial delays. It can issue subpoenas, determine witness fitness, and manage the process to avoid abuse or unnecessary adjournment. Ultimately, Kanu's witness list test the spirit of Section 175, which upholds inclusivity in testimony while preserving the court's discretion to ensure fairness and efficiency in the pursuit of justice. I still have with me Barrister Vansofeli. Thank you so very much, Barrister, for being here. Now, this might be a little bit difficult, especially for people who are not well into the law, the legal thing and all that. But I'd love you to maybe take us back to how it all started, because I made a little research here on historical context of what we have to say today. They say the Nigerian rules on competency and compellability were inherited from the English common law applied during colonial rule. It was codified with the Evidence Ordinance of 1945, later becoming the Evidence Act Cap E14 and so many other things. Help us, please.
Yes, so the Evidence Act is the law that governs how evidence are tendered and admitted before a law court. In Nnamdi Kanu's case, you know, after his sojourn in exile, he was arrested in Kenya and rendition to Nigeria, okay, wherein a lot of comments have been made as to that effect, and the Court of Appeal have said they should let him go. The prosecution appealed, and when they went to the Supreme Court now said that recently, after the prosecution opened their case and closed their case, the defendant, Nnamdi Kanu, filed for a no-case submission. Now, the no-case submission was overruled by Justice James Omotoso of the Federal High Court, Abuja, and asked that Nnamdi Kanu open his defense. Before the protest, his lawyer joined the protest, and the lawyers were arrested, and now the case is ongoing. Yesterday, in the course of opening his defense, he made an application to list witnesses, 23 of them high-profile Nigerians, both governors serving and past, and you know, even ministers and the rest of that, including the former Attorney General of the Federation, Malami, 23 of them as witnesses. Now, under the law, Section 175 of the Evidence Act says that all persons shall be competent to testify, except the court consider that they are being prevented from understanding the question put to them or from giving rational answer to those questions by reasons of tender years, extreme old age, disease, whether of the body or of the mind, or any cause of the same kind. Then subsection 2 now said that persons of unsound mind are also competent to testify.
Persons of unsound mind?
Yes.
Really?
They are competent to testify as long as they are able to give rational answer to questions put to them. You understand me? So, the law in Nigeria is that everyone is competent to testify. The only time that capacity is withdrawn by the court is where it can be obscured by infirmities. Okay, that's why I say all persons shall be competent to testify, unless the court, you know, discover that these persons that are all competent to testify, they are not able to answer to the questions put to them by several factors, by reasons of tender years, extreme old age, disease, whether of the body or of the mind, or any cause of the same kind. So those are the exception. Apart from all that, infirmities of the mind, and everybody is competent to testify. What the implication of this, therefore, is that those persons that Nnamdi Kanu have listed must come to court to testify. The court will subpoena them. Subpoena under the law is where a court makes an order compelling, that's what it's called, compellability, compelling a witness to come to court to answer to it. Now, that's the evidence as speaking in section 175. However, the mention of people like Sanwo-Olu and any other serving governor is obscured by section 308 of the 1999 Constitution.
Okay, which says?
Which says that governors, presidents, deputy governors, vice president are immune, okay, from criminal prosecution or trial, or to come and enter the witness box or come and do any of all that and all that. Because section 175 speaks to the general all persons, if section 175 goes at variance with section 308, the law is that when a federal law, okay, or when the Constitution, provision of the Constitution, is having clash with the provision of any other law, the Constitution shall override that other law. That's section 1, subsection 3, which says that if any law is inconsistent with the provision of this Constitution shall prevail, and that other law, to the extent of its inconsistency, shall be void. Okay? So, the implication here is that every other person who is not a governor, a deputy governor, president, or vice president, you understand, are exempted from that list by virtue of the provisions of law. So the other ones left have no immunity. A serving minister have no immunity. Wike will have to appear, subpoenaed by the court. Okay, the other ones, all who do not have those, the aforementioned offices as expressed, are competent and they are compellable witnesses. Meaning that first, they are competent to testify. Second, the court can compel them, bring them under compulsion to come and testify.
But speak to us on the parameters that determines a witness. Can someone just wake up and say, this is my witness, and the court assumes that the person is okay to be a witness in this particular case of Nnamdi Kanu? Can't this be said to be winch hunt?
No, you cannot just wake up and point to any direction and say this person is my witness.
So why shouldn't Nnamdi Kanu? Because the people he is calling here, you ask yourself, how do they connect to his issue?
He brought an application before the court. Now, the likes of Malami, the Attorney General of the Federation, was the person who orchestrated his arrest and rendition from Kenya. So he's calling him as a witness.
Theophilus Danjuma, how does he connect?
I don't know how Theophilus, and I don't know how someone, the governor of Lagos State, you understand? So it is him who is calling, because I'm not on trial.
Yes.
He's the one on trial. So it is him that will, put that forth, how these people are his witness. Because the truth is that you cannot also hide under the guise of law to bring in irregularities for the court to admit. You understand?
Exactly.
Section 1 of the Evidence Act talks about relevancy and admissibility of evidence. Relevancy.
Exactly.
So the evidence must be relevant to the fact in issue. The fact in issue is that he's been accused of terrorism on the basis of broadcasts made, orders given, and so many other issues. So that's the fact in issue. Now, whatever evidence that the court will admit must be evidence that are relevant to the fact in issue.
Okay.
You understand? Based on the Evidence Act. So your evidence must be relevant to the fact in issue.
And if the court
Now,
finds
it is possible.
None of those relevant, what happens?
What happens is that the adverse party, that's the prosecution, the prosecution will object to the admissibility of that evidence. Because first, the evidence has to be an evidence that's relevant to the fact in issue. Some evidence are not relevant to the fact in issue, but they are relevant to the relevant facts.
Come again. Some evidence are not relevant
to the fact in issue,
but they are relevant to
the relevant fact.
Please help us break it down.
Now, what I mean is this. What I mean is this. Let's say A is a fact in issue. You understand? B is not relevant to A. That's the fact in issue. But B is relevant to the relevant facts. How do I explain this now? Now, there are facts. We have facts in issue. We have facts relevant to the fact in issue.
Very well.
You understand? Then we have facts that are not relevant to the fact in issue.
Okay.
But they are relevant to the relevant fact. Let me say A, B. A is relevant to B. That's the fact in issue. A is relevant to B.
Yes.
You understand? Then C is not relevant to A, but it's relevant to B.
Oh, okay.
That's the relevant fact.
Okay.
So all this evidence are admissible in their class. And the fact that an evidence is admissible or presumed admissible does not mean the adverse party cannot object to its admissibility. So in the case under reference, the likes of Sanwo-Olu and others, I don't know how they relate to this issue, but the prosecution is there, okay, to, you know, and these witnesses that Nnamdi Kanu is calling, putting them forth, they are also subjected to cross-examination by the prosecution. I don't know what I mean.
Very well.
Because when the prosecution opened their case, Kanu Agabia said, cross-examine the witnesses that was presented by the federal government and all that, the documents and all that, all material evidence. The same thing applies when you sweep the coin to the other side. You bring all these witnesses, and a witness can become hostile. A witness can become tainted. So that's what they call a hostile witness. If you bring a witness, see, it's not enough to list witnesses. You can list witnesses that will ruin your case by yourself, bringing people that will ruin your own case. So it's not enough to have 26, 23 witnesses. That is why, if left to me, I would have suggested that they allow Kanu Agabia to take on this defense. But it doesn't look like what is going to happen, because we're hearing now that the SCN is withdrawing.
Yes, we just learned that now.
That the SCN has withdrawn. And then Kanu himself, his two lawyers are in detention. One is available, that's Maxwell. Aloy Jimako, his brother and others are in detention. Now, as we speak, I'm being told that Kanu himself is conducting the trial. Under the law will tell you that you can defend yourself.
But does it really hold any water?
No, that's what the law will tell you. What the law will not tell you is that you will get stuck. You will get stuck. That's the truth. Because the court this morning informed Kanu whether the court should provide him a lawyer, because that's the procedure in law. If your lawyers are not available, or you don't have resources to get a lawyer and all that, whatever the reasons, it is the duty of the court a constitutional duty of the court to provide you a lawyer that will, undertake your case. It is his right. But he declined that and said he's going to defend himself. And I do not see him making sense. I mean, I know the laymen, people outside that say, he's doing it well. But for a lawyer, you are journeying to nowhere.
Because for me, it is beginning to look like maybe in the past he has watched Suits. And maybe feeling so motivational that maybe he would love to defend himself and the possibility of doing that. But don't you think all of these things are headed towards a particular way that we might not know what the results might look like? Because Kanu on his own would not want to do that if he didn't get some advice to go ahead.
No, because the truth is that even if you have to defend yourself, not in a case that has to do with capital punishment. Maybe you have some simple offense, you committed a simple offense and your lawyers are not available and you want to undertake that. Not like you are stunt or maybe like content creator or something you are doing. Not a case where the outcome is death. That's the penalty for the alleged offense because it's an alleged offense. Okay? So, I would have suggested that Kanu Agabi sends, bro, because if you watched Kanu Agabi during the trial when the prosecution opened their case and when it was cross-examining the federal government, you will know why I'm saying what I'm saying, okay? And this is just my own token of advice. We cannot preempt the outcome of the case. We're not expected to do that. We can only talk about the surrounding situation and the circumstances, what is expected of either party, what the law says. That's what I've said here, Section 175. Everybody's competent and everybody's compellable. That some persons, because of immunity, presidential immunity, the governors, those ones cannot because of the issue under reference. So the bottom line here is this is a case of interest. It's not just a high-profile case. It's a case also that is sensitive because of the tribal issue that has been brought into it and the issues of discrimination, alleged discrimination that have been talked about. So many persons have gone as far as talking about the pardon, persons who were pardoned, insurgents, Boko Haram insurgents and bandits that the government is currently, negotiating with, and they are giving government conditions here and there, and they've also brought that home to the case. And
currently, the ones of the three names that President Bola Ahmed Tinubu just granted clemency.
Yeah, that's what I'm talking. That's the pardon, the prerogative of mercy I'm talking about, and all that. So a lot of persons have juxtaposed this and said that there's serious bias. And why can't the president instruct the Attorney General of the Federation to take over and discontinue the matter, under Section 174 of the 1999 Constitution and all that. So there are a lot of here and there. But just at the actions taken so far, we must let the public know that. Because I've listened to so many persons who are saying, the 23 witnesses is not, why should you do that and all that? But it's not improper by law. It's not, nothing is wrong with that move as we speak now, okay? The only thing I faulted in this whole process is what he's doing today to defend himself. What he's doing today may not be the best for him in the case on that reference.
All right, so speaking about the 23 witnesses, the layman on the street would ask, when a witness comes, is he speaking for or against the one who has asked that he should come?
That's what I'm saying, that a witness can turn out to be hostile.
No, in this case now,
yes.
Are they speaking for or against?
That's what I'm saying. It's left to them. It's left to them because usually when you are bringing witnesses, you are bringing witnesses that will help the cause of your case. Okay? Now, if you now subpoena a witness, maybe a witness with a document, and he has refused to give you the document, the only way you cannot go and fight him or to, you understand? You can only ask the court to subpoena him to come and talk about that document, to impel him to, or to come and talk about that fact, the material fact. But they are coming to give evidence, which is fact. You understand? They're not coming to give law. It's the court that will marry law to the fact that they've given. You understand? So we've seen witnesses, we've seen a situation where witnesses, you know, are being asked questions and they'll keep mute. Okay? They will refuse to talk. And in the circumstance, when that happens, the law is that the court will have to probe whether the muteness is as a result of infirmity, or whether the muteness is as a result of the visitation of God, or whether the muteness is malicious outright. In law, one will say whether the muteness is as a result of the visitation of God. What we are saying is, in essence, what it means in a plain man language is whether the muteness is orchestrated from mental ailment or infirmities of the mind. That's what we mean by say visitation of God. So when a witness becomes hostile, there are legal processes. Okay, the law have made provision for everything around the situation. So for some of these witnesses, we can relate them to relevancy into the matter, but some of them are outrightly very extraneous in the case under reference. So it is the way they go about the case from here and the responses they get from the witnesses that will determine how far the case is going to go.
But do you think that what we have today with our judiciary, that the gusto would be there to invite these witnesses, really, knowing how symbolic these people are?
No, the court will, if they don't come to court to give evidence, they will be subpoenaed.
Really?
Yes.
Nobody like Nyesom Wike would love to go under that.
We will subpoena, and he's listed as a witness. The court will want to hear from him now.
So there's no lacuna that could make Nyesom Wike or Ipasu to say this is all a charade.
No. They are listed as witnesses. They cannot escape. They cannot escape it. They will be subpoenaed. If they are subpoenaed and they refuse to come to court, it's contempt of court. And then they can be sent to prison. Yes, because they will have to come and show cause. If they don't do that, they will put them in prison.
But Barrister, you speak like this is the classroom, but we all know how it works.
No, I'm not.
In our classrooms, of course, 1 + 1 is equals to 2, but we all know how it works outside of the classroom.
No, this one is not about classroom. This one is the law.
And you think it would hold?
Why would it hold? Was it not in this country that because sometimes we feel that the whole country has broken down. The country has not broken down completely. Was it not in this country that governors were convicted and put in prison? Kanu, Ojuzo Kanu, the former governor of Taraba State, Alamesia, Joshua Dare of Plateau State, mentioned them. They went to prison. Obasanjo himself was in prison. So I don't think that we are completely gone to the point where we can no longer trust the system to act the way it should act. I mean, they will come to court to testify. They will come to court to testify. Once they are subpoenaed, they will come to court. If they don't come to court, they will go in for contempt.
Yes, but Nnamdi Kanu has asked for 90 days to go through whatever.
To be able to finish up with his.
So what does that mean?
To open his case and close. The window within which he will open his case and close same. You know, we are operating now through the new Administration of Criminal Justice Act. You understand? The new law. That's why the adjournment, you see that the adjournment is almost every week.
Yes.
It's the law that says adjournment should not go because they want to facilitate. This Nnamdi Kanu's proper trial now started not too long ago.
Really?
Not too long ago, but all the while they were talking about interlocutory applications, bail application, and all that. Those were the things that took a lot of time. The trial itself started this year. this year, that's the when the trial started. This particular year itself. So, and you can see that we are going to conclude it this year with the way we are going. Okay.
But with this
90 days will be like,
now, won't it
maybe at the
next year?
the first quarter of next year, we'll conclude the case.
But is that to his advantage?
Well, it's not about advantage or disadvantage now. It's about trial.
Because I'm looking at the duration now, and I'm asking myself.
He said within that time, within that time, you'll be able to call up all his witnesses.
Oh, okay.
You understand? I mean, if you are calling 23 witnesses, and you know the matter is not every day.
Oh, okay.
It will take some time before you're able to discharge. Even in a day, you may not be able to call more than one witness or two in a day. And if you have 23 and you intend to call all the 23, well, I know you cannot call Sanwo-Olu because it's not in the category. But when we remove those ones, whatever is left, that's what you intend to call. But the defendant can list 23 witnesses and call only one or two. He can decide to call all. You understand? It depends on him and what he wants and how he wants the case to go.
All right, so let's maybe take a look at other matters still connected to this case. Ejimako is currently in detention. The brother to Nnamdi Kanu is currently there. Another lawyer too is equally there. We just learned that Showore has equally been taken, away, and then all that. Especially for the lawyer Ejimako and his colleague there, they were protesting. According to the media aide to the police, it said that they had the right not to do that. And I'm asking, how does it really work? Can the court actually ask people not to protest?
Not like the court can ask people not to protest, but they are citing sub judice. That when, and the rules of professional conduct, when you are a counsel in a case, okay, and you have subjected that case, you have submitted to the jurisdiction of that court, and you are in the case, you should not resort to self-help. So those who hold that school of thought, it said that Allah Jimako's participation in the protest, free Nnamdi Kanu protest, and that of him especially, the brother and others are not lawyers, so him especially, that it amounts to self-help. And it runs foul to the rules of professional conduct, our ethical code in the legal profession, and so he should be disciplined.
He's a senior lawyer. He should have known this. So
he should have known. That's one school of thought. Okay. You understand? I have argued vehemently against that position, and I've held the view that it is a constitutional right of every citizen, okay, to protest. Every citizen. Any citizen can protest as long as the protest is peaceful.
Even if it runs against the Constitution, which you said, if compared to the Constitution overrides it.
No, if you go there now, I will tell you that Allah Jumako did not commit any offense. Because it is the rules of professional conduct that say lawyers should not. Rules of professional conduct is a lower legislation. So if you go there, I will tell you that the Constitution in chapter 4 overrides any ethical code that you want to impute. You understand? If really Azum were not conceding that it went totally outside the ethics of the profession. You understand? So there is no law that said that a lawyer cannot protest. And remember, this is a peaceful protest. Okay? How be it that it is tagged free Nnamdi Kanu? Now, the second lawyer, that is Maxwell, have argued that the free Nnamdi Kanu expression was not directed at the court, that was directed at the federal government, for whom in time past the court had asked that Nnamdi Kanu be released, and the federal government did not yield to those accounts. And it was on the basis of that. So it is neither here nor there. So why you can argue that it is violation of the rules of professional conduct, why you can argue that successfully. You can also argue from the human rights point of view. You understand? That making a complaint to the federal government and protesting ultimately peaceful to the federal government does not amount to a breach of professional conduct. You can argue that successfully. So let the court now look at it and decide. So
in this case, so how do you think? Well, of course, we are not
we
here
cannot
to
preempt the court.
The
we can only lay down
exactly.
Whatever the facts are. The court will look at the law and look at it. See, the law is what the court say the law is, not even what we are saying. Okay, so the court will decide, because now they are going to face trial. Because
tomorrow.
Yeah, they have been remanded at Kuje prison. Yesterday, before yesterday, the lawyer to Jemako and Nnamdi Kanu's brother filed a bail application. But the prosecution was not in the court. So they have an adjournment, and so the matter will be looked into.
All right. This is a developing story, actually, and we hope to, keep feeding you with them as they unfold. It's becoming a little bit complex here and there, especially with Showore, who has been picked by the DSS and for his presence.
The police.
Yes, the police, sorry. For his presence at the court hearing today. I do not know how this would unfold, but don't you think this is definitely going to make the presidency and this administration look very bad?
Well, they should. It's their responsibility. They took an oath of office to defend the constitution and to secure the territorial integrity of the country and to make the country, keep it peaceful within the ambits of law. So this is the assignment they have been called to do. The police have invited Showore. In fact, they even followed them to the IG's office just this morning. So the days to come, we'll know exactly why they're inviting him, what the offenses are, the charge. The police claim that there was an order of court, okay, stating that there should be no protest, okay. They claim so, but under the law, elementary law, a man that has not been served an order of court cannot be violating an order that he has not been served with.
But it's been stated that you can serve it anyhow you feel. It could be on social media, it could be on newspapers. Once it is represented there,
the police did not show me one newspaper or one social media post on the police force.
Because Hundeyi said that they did.
They did not. He said it, but he couldn't provide it. He was asked by a journalist. Yes. He couldn't provide it. So you cannot have an order and keep it in abeyance and keep it in your own house and then be compelling citizens to do. And additional, let me add about the 90 days talk about for Nnamdi Kanu's case. It's also constitutional. The constitution also provides that the defendant must be given adequate time and facility to defend this case. You understand? Adequate time and facility. The constitution even did not even restrict it to number of days. Adequate time. What is adequate time under the law? It's not spelled out in number of days, just to add to my argument. And on this issue, where we talk about the court order, the police cannot sustain that argument that an order that is not served on a person, on a defendant, he should be binded by that order. Who moved the motion ex parte, and in what court was the order made? and under what circumstance. We don't have that. So the police just goes chasing. They just want to do illegality and to act as if they are proper before the law. They're not proper before the law. Let them prefer charges and cite the order and come to court to tender it as evidence and tender how it was served on the general public before the court. They will not be able to do it. And so that is what it is.
All right. But do you think the NBA would serve as an onlooker, especially for their colleague, or do you think it is beyond them to...
The NBA, I've not seen any statement from the NBA for now on the issue. The last time we heard from the NBA was on the tinted glass matter. So this
which they succeeded.
Yes.
We'll give it to them.
This particular one, we do not know where the NBA signed yet until they issue a statement on this issue. The ESCO perhaps will look at this issue and issue a statement in no distant time.
All right. So we would leave it at this particular point. The Nnamdi Kanu case is a wonderful one, especially for students of law. You know, they would have so much to learn from this because of it's a little bit complex for some of us journalists, but for those who are reading this, it's a wonderful experience for them to use this as a reference for so many other things that they would love, you know, going on. Thank you so very much, Pastor.
Well, it's my pleasure.
All right, that's about time. We love to go, but please do well to follow us. You can read up on everything we've talked about today when you visit us at enterprisetvnews.com. You may equally rewatch, if you may, when you visit us at Enterprise TV7. I am Henry Igwebike. Thank you for watching, and we'll see you tomorrow. Bye-bye.